This channel does not promote any violence, harmful or illegal activities. All content provided by this channel is meant for educational purpose only.
1501.
After referring to the NCLT rules, which seem to have been followed in this case, we said that issuance of a notice to the authorized representative of the respondent bank was not enough to satisfy the mandate of the proviso to section 7(5)(b) of the IBC. The IBC being the substantive legislation relating to the application filed by the respondent bank under section 7 thereof. The notice to cure the defects therein necessarily had to be given under the said provision, and compliance with the rules independently framed for the National Company Law Tribunal was not sufficient. We are of the opinion that even though the registry of the NCLT issued process under Rule 28 of the NCLT rules, the same was insufficient as there was no communication of a notice under the proviso to section 7(5)(b) of the IBC at any time. We therefore find no error having been committed by the NCLAT in holding to this effect. However, the NCLAT ought to have asked the respondent bank to cure the defective affidavit at least at that stage, instead of ignoring the same and directing the NCLT to proceed to hear the company petition on merits and in accordance with law. To that extent, the NCLAT was in error. The appeal is accordingly disposed of, directing the respondent bank to cure the defects in the company petition, including the defective affidavit, within 7 days from today, and the National Company Law Tribunal, Ahmedabad, shall thereupon take up the matter for hearing in accordance with law and due procedure.
8 minutes. Item number 801.
801. We are informed that the matter is tentatively directed to be listed on 2/12/2025, shall not be deleted from the said date.
Item number 802.
Not to be deleted.
May I mention item 57?
Let
I'm
me-
seeking a short accommodation.
We'll have to wait till the matter reaches.
With your lordship's permission,
Yes,
can I, my lord, mention that BOCW Act, which your lordship had,
yes, yes.
my lord, your lordship had given us 1 week's time to file written submission.
You want more time?
Yes, my lord, Miss Gunjan Sinha was appearing with me. Her mother-in-law, my lord, passed away on Saturday morning.
Very
So
good.
instead of 1 week, can your lordship just give us 2 weeks time, my lord?
Make it 2 weeks.
I'm
Please inform the other side.
Yes, sir.
Item number 1.
Lordship,
Yes.
this matter, the counter has to be.
Counter is filed now.
Still yet not received.
It was filed yesterday,
It was filed on Saturday. then
Saturday, or
filed. So
We did not get any
you didn't
receiving.
receive it.
So let me inquire. If
Please,
you
the housekeeping
send the
is not-
email, then let me check.
Very short counter has been
Very
filed.
short
but,
counter has been filed.
No, but you still need to share it with them.
Lord, I have already shared it, but these are.
We don't
housekeeping
have the
bills
proof
also.
of actual service here because the registry doesn't insist on filing a email copy, or
Lord,
how do you communicate it?
Lord, email.
Email. So we don't know whether he's received it. You sent it to the correct address.
Kindly listed on 28,
Very
no, 28 now,
Learned counsel for the petitioner states that he has
Friday.
received a copy of the counter filed by the state. Learned counsel for the state shall furnish another copy to the learned counsel for the petitioner. Rejoinder thereto, if any, may be filed by the next date of hearing.
28 number.
He's in jail still. So 20?
28 November, Friday. Coming.
28th November.
Thank you.
28th.
This matter I am seeking.
Counter affidavit is not.
Lordship, kindly take on record my appearance, Lordship. I
Yeah.
could not file, please.
Counter affidavit is not yet filed, Ms. Patil. We didn't
You
receive
have
it.
not a copy.
You've received a copy of the counter?
I have
They've also not received.
I have no information. I
Malas, we take steps.
The office report is dated 21st and it says counter not filed.
Malas, we filed it yesterday, that's why, Malas,
Very
what you may say, we
Learned
take it on.
Learned ASG states that the counter was filed yesterday.
Yes, Malas.
Filed yesterday. E-filed yesterday.
Yes.
Well, we will not find the same on the court.
He's in DC, Lordship.
Learned counsel for the petition. You shall also be furnished a copy Then counsel for the petitioner should also be furnished a copy of the counter. You need to file a rejoinder, you will have to explore that.
It's what we
Rejoinder there too, if any, may be filed by the next date. How much time would you
said 2
require?
weeks or 1 week, not much.
Based on 8th December.
Obliged.
My lords, some item 3, my lords.
Yes.
Expect 3 opportunities, my lord.
No counter.
They have not filed a counter, my lords.
Counter.
This also we filed, my lords. Maybe we filed.
No, with regard to that house being,
Yes, my lords.
My lords, we
But-
have filed on 21st in this, my lords. I'm sorry, it's
Not
not
on
on
record.
record.
have you received it?
Yes, my lords. I'm
You-
carrying the copies, my lord.
No. You've received the counter?
Yes, yes, my lords. I'm. Mistake.
Two things we are saying, my lords.
No, but we don't have, what have you said in that with
Two
regard to
things
this
we
house?
said, my lords. One, ownership of the premises does not have an impact on the NDPS.
But how do you pin it on him then?
So, my lords, on that.
Was he there at the place?
Yes, he was there. He says that he has taken, these are unauthorized occupations going on in the.
How would he take it on rent? With occupation, whom does he take it on rent from?
Yeah, my lords, that is all.
No, but there's a lease deed. In his-
No, no, that is his statement. His statement says that he is taking, para 3, if you're not.
How do we
Yes,
go by what you squeezed out of him
No, my
in
lords,
terms of a confession?
my lords, permit me to then show what is there in, against him. One is, my lords, the recovery of the contraband. Second is recovery of the pistol. And third is CDR.
Or he was present at the spot?
Yes, my lords. So if I can show to your lordships the recovery.
You need to file a response to that? To the counter, this is a counter to the IA, is it? Counter.
In the charge sheet also on page 51, the ownership was a matter which was awaited. If your lordship sees
No,
it.
but we have not seen the counter because it's not yet been put on. If you had the privilege of looking at it, then you will have to tell us whether you need to respond to it. If you do, then we'll give you some time.
My
Otherwise,
lordship may have a look. My lord.
no, but you are caught on the spot with all these drugs.
On the second, not on the first instance, subsequently.
What do you mean?
First, the first accused one, if your lordship just have a look. We came little later,
Literally was not there at the spot?
on the same day, but subsequently.
What do you mean subsequently?
I'll tell your
You
lordship.
walked into a trap.
Which page? Page 35, your lordship have a look.
Page 35.
First, it starts from. First, if your lordship sees a 33 para 3,
Yes.
first, when they came to the place, one Moinul Islam was there. And your lordship will find
Right.
that page para 3, page 33.
Yes, that's
And that-
right. Then when do you come in? Page 35, para 9.
Para 8.
Para 8. Para 8. Two persons arrived.
In the meanwhile.
This is house number B by 71.
Right.
That's it.
Now, the A1 Moinul Islam has been granted bail by the High Court.
Moinul Islam is supposed to be your driver.
Man, and he was the first who was there, and he has been granted bail on by the High Court. And your lordship would find that para 65, page 51. Even when filing the charge sheet, ownership was a matter of doubt. Page 65, para 65, page 51. Letter was sent to DGM NF Railways for ownership detail of the seized place, so and so, so and so. Reminder, in this regard, is awaited. No, in the additional document, we have filed the response. In the IA that we have filed,
Yes.
your lordship sees page 8.
Yeah.
First, the government of India seeking the requisite information from the railways. That your
Yes.
lordship will find at page 8.
Very well. The reply is at 9.
And the reply is at page 9, that is 20th May 2025. In terms of your letter under reference, it is to inform you the railway quarters, actually, it should be written as so and so, has been lying vacant since 2004. These officers want to inform you that there was a lot of unauthorized occupying the vacant quarters. In this regard, a letter was received from DGM NF Railways dated 1/11/22 regarding occupation of railway quarters by unauthorized person. Accordingly, a reply was sent to DGM while letter dated 23/11, which is enclosed for your kind information. If your lordship sees those two letters at page 10 and 11, 10, that is 2022, unauthorized occupation of railway quarters by railway employees.
Yes.
With reference to above, furnishing herewith below following information to your good officers for appraisal of statutory audit, so and so. With reference to point 1, the following table is shown. In this house, your lordship will find that serial number 51 at page 11.
The number seems to have changed somewhat. B71 is now E71-B. Is it the same house?
Minor, that's what they say. In the previous letter, if your lordship sees at page 9,
Yes.
second line, in terms of your letter,
E71.
just inform me, actually it should be written as E.
E71-B.
And that your lordship will find that serial number
Dimple Saha.
Dimple Saha.
So,
He's been in custody for almost 3 years.
and what is your explanation for going to that place? You were caught there. And Moinul Islam is your driver.
He has been granted bail, my lord.
No, but he was inside when
He
they
was the
knocked on
first
the door.
person, yes, my lord.
And he says that you and that other gentleman, Anwar
I and the other driver came subsequently, my lord.
Atikur Rahman.
Atikur Rahman, accused 3.
Atikur Rahman is also your driver.
My lord, so we came
So-
together.
You're not a driver though.
I'm not the driver. Now, my lord, so far as A1, that your lordship will find,
There seems to be, and it's
there is no criminal antecedents.
no criminal line.
No antecedents, but the status of trial also your lordship should know, Manas. Out of 12 witnesses, 4 have been examined. And there are total 3 accused, Manas. Only 1 is on bail. And 2 and 3,
Atikur is also in.
are both in custody, Manas. And my respectful submission would be, your lordship may permit me to show what is there in the charge sheet query. Because one is, Manas, your lordship already saw at page 35, para 8 onwards.
Yes.
He arrives in this Innova at the site and the search and seizure is going on.
Yes.
And we see what is he saying? One being asked, they told your name as so-and-so, so-and-so. House was there, search and seizure was going on, place belongs to Jitul Ali, he works as driver. Then Moinul Islam told that Atikur Rahman is also driver of Jitul Ali. Moinul Islam further told that Jitul Ali and Atikur Rahman come to this house every day. She so-and-so, Ayush showed his ID card to Jitul and so-and-so. Shared information. Then PC para 9, search in the Innova in which they arrived. During search of Innova Crista car, 1 pistol with mark so-and-so, 1 empty magazine was recovered from the dashboard, glove box of the Innova Crista so-and-so.
This is the car that they came.
This is the car that they came in.
Only
So,
the
Manas,
contraband that was found in the car.
Sorry?
Contraband.
That's
No
correct.
doubt, but
And we see the
all the
contraband.
parts put together, Mr. Goswami, it's very
So,
difficult.
my lord, I think.
Contraband also.
Look at the amount
No, I'm
of.
not, my lord, I'm
Some
going to the very.
customized tablet,
Your lordship,
79.
1,000 kgs of heroin,
Why not?
16 bottles of,
Not 1,000 kgs, 1 kg.
One-
sorry, 1.2.
1.028 kg.
So full bouquet of, malab,
My lord,
They're catering to all levels of addiction. They've also got cough syrup there.
my lord, the main person who was first caught, my lord, he has
No,
been
but with
granted.
these quantities being caught there,
Moinul Islam, your lordship will see at page 90.
he's your driver. That's perhaps the reason why he's.
So, my lord, on grounds of arrest, your lordship, page
19 is the.
90, which is the page? Bail order. 98 it starts, my lord.
98.
My lord. Then 108, 109. Para 19, man. There also he was for more than 2 years. I am more, my lord. And at point of time also only 3 were examined. Para 18 onwards. It cannot be denied that the accused is behind bar for more than 2 years, 6 months. From the date of arrest till date, the
Only on the ground of the length of
Then
incarceration.
also only 3 out of 12. Today also only 4 have been
No, but we still need to give some respect to section 37. With these kind of seizures, if we let people off lightly, what kind of signal would be?
Whether the person who was there in the first instance, maybe my driver, he is being granted bail. I am, my lord, behind bars for more than 3 years now, my lords. Your lordship may put me to any condition. There is no criminal antecedent.
Not at this stage, Mr. Goswami.
My lord,
Remain for some more time.
your lordship will give me some liberty to approach the court.
We'll say only at this stage. We are not inclined to interfere with the improvement document at this stage. Especially petitions according to this list.
Some liberty to move against.
That's why at this stage would indicate that after some time you can perhaps.
If your lordship could indicate.
That should be indicative enough, Mr. Goswami.
Deep down.
Yes.
It's a regular bail, my lords. There were 2 incidents, my lords. One at.
They have filed a very detailed counter.
Yes, my lords.
Please, my lord.
My lords,
I'm appealing for the state, my lord.
Online.
Please, my lord.
Oh. Yes. How do you establish that it was 2 separate incidents?
Yes, my lords.
This
My lords,
video
at
which
page-
shows
page
you pelting stones from the terrace.
Yes, my lords. At page 60, my lords, of the charge sheet, my lord.
Page
Page 60, my lord.
60. Yes.
Para 4, my lord. 4th
Yeah.
line. During that time, accused Iqbal, who is Nambardar of the village and respectable person, told us to resolve the matter amicably and not to repeat this kind of act in future, and on social grounds to have a discussion in the evening, as Akbar and accused person live close to each other. That is why we decided for evening for everyone's convenience. Now, my lord, the second incident which comes at on 5/4/2024, being last Friday, the holy month of Ramzan, all the family members went to offer Friday prayer at village so-and-so and mosque so-and-so, came to our house and
No,
went.
but the first incident, where does it
Yes, my
mention
lord.
that
That
you
is
were on the
at
roof and
page 59, my lord, para 2, my lord.
two?
Yes, my lord. On 5/4/2024, around 10 a.m., the accused began abusing at Akbar's house and accusing his boat eating their leaves and plants, starting quarreling.
No, but there's no mention of anyone being on the roof and.
Yes, my lord. That's what.
Stone.
Now, my lord, the role, my lord, on which this FIR has been registered, at page 61, my lord. Third line, my lord.
Yes.
Farooq was holding the hand of Uwais so that he cannot save his life. Haseen and Iqbal grabbed Uwais from behind and make him fell on the floor. Rafiq alias Rafa grabbed Uwais' legs, sat on them, and Fardeen grabbed Uwais' hairs with both hands and made him fall down on the floor. And Nadeem stabbed on Uwais' chest with a knife which he was holding in his hand with the intention to kill him, due to which Uwais was flooded with blood. Daraj stabbed Uwais on his back with knife which he was holding in his hand, and Quash struck him and with danda on his body. All the accused persons have been beaten, deceased mercilessly. There is no recovery from me, my lords. There is no injury caused by me to any to the deceased as well as to the complainant party, my lords. My lord, there are total 13 persons were named in the FIR. I have been named in the supplementary statement that was registered the next day, my lords, out of which 9 additional persons were also named in the supplementary statement. My lord, total 22 accused were there, out of which 14 were exonerated, my lord. Charge sheet has been filed against 8 persons, my lord. There is no criminal antecedents against me, my lords.
Where is the mention of you in the charge sheet?
My lord, that is, I have been arrested just as an accused, my lord. That
There must be some mention of you in the charge
yes,
sheet.
just a name, my lord. That is there. Yes,
Where is that?
exactly. That is
Other than the concluding paragraph.
that yes, my lord. And at page 58 as well as the concluding paragraph, my lord. That's it. There is no role against me, my lord.
Page 58, you're there.
Just a name, my lord. That is just a name. The subject part and the concluding para have been named.
There's no specific.
No specific allegations against me has been attributed to me, my lords.
Yes, counsel for the state.
Please, my lord.
What have you said in the counter with regard to the specific overt acts attributed to you?
My lords, with respect to this, my lords, my instructions are, my lords, that there is two families, they are in quarrel with each other.
Don't
my
give
lords,
us, don't give us general information. What have you said about this man in particular? In the charge sheet, there's no specific overt act attributed to him. But
please,
somewhere
my
I
lord.
read that you said that he was standing on the roof and pelting stones on the people.
Please,
who were
my lord.
trying to-
And the photographs have also been annexed, my lords.
What time was that video? According to him, there were 2 incidents on that day, one in the morning, one in the evening.
Please, my lord.
Then what time is the video? Is it the morning video or the evening video?
Morning.
That is the specific case, that the video which is showing him pelting stones was in the morning, which is not the fatal attack. The evening attack is the fatal one. What did you say about that?
With respect to this, there is a in the comments, this particular aspect has not been pointed out.
That is his entire case. What do you mean by
In fact, I have called the IO if
counter without meeting the point.
please, if lordships, I have called the IO for taking direct instructions in order to have the discussion. If lordships can just give me 2 days time, I'll come back, with the specific.
Pick it up on Friday.
Please, madam.
Not Friday, Thursday.
Grateful.
Thursday. At the request of the non-council for the state.
Please.
Item number 5. I note permission will be granted to withdraw the SLP as the petition has been admitted by the Honorable High Court by the order dated 16th of October 2025.
What this is?
Because there is a issue of POXO in this, and the only theory was PW3 who had seen the petitioner.
Last scene.
So last scene theory corroborated by nothing else, my lords. This was only under section 25 and 26 of the Evidence Act, where there was a confessional statement before the police. That is the reason.
When the state comes, then we'll ask you to come back again. The counsel for the petitioners have permission to withdraw the special leave petition, as the petitioner has been acquitted by the High Court in the pending criminal appeal. Norms are pending in the criminal appeal from which the present case arises. Especially the non-delay petitioner as well as the special petitioner according to the witness does withdraw.
Item number 6. May I please, my lords? My lords, this is against the grant of bail, we are for the state.
But merely because statutory bail is granted and thereafter you file a charge sheet, it does not automatically mean that you ask for cancellation.
No, absolutely. Therefore, my lords, I'll take you, my lords, through the merits of the case. My lords, kindly say he is a fact.
You have to seek cancellation of that bail. You've not done that.
No, we haven't done that.
So far as the grant of the statutory bail is concerned, that was justified.
That was justified.
Then against that order, what is the SLP that we are going to do?
The only thing is that
if sufficient grounds are made out for you to seek cancellation of that bail, go before the High Court then.
yes, my lords.
Or the trial court, whatever it is.
Yeah, my lords.
So far as the grant of the bail is concerned, there's nothing for us to say.
With liberty to move the High Court record that otherwise
Counsel for the petitioner seeks permission to withdraw this special leave petition, reserving liberty to the petitioner to approach the trial court of High Court for cancellation of the bail in the event sufficient grounds are made out therefore.
Subsequent developments,
No,
whatever way
don't know what.
to put it.
That judgment is there of this court, which said that you don't need violation of the bail conditions alone. You can even go on the merits if sufficient grounds are made out there. So on the basis of that, you can still ask the court to look into it.
My lords, I'm so grateful. Item number 7.
But also delay condone the petition as well as case. Yes.
Lord, this is for anticipatory bail, Lord.
Well, you come on, when was the order passed? May, but the FIR is of October 24. So 1 year.
There is some delay, Lord.
1 year, why should we entertain this?
Lord, kindly see, he is...
By now, they might have initiated steps against you also.
Lord,
the FIR is 1 year ago.
Lord,
charge sheet was filed in December 24.
This charge sheet is filed. Lord, everybody is on bail and I am a cancer patient.
But even then, if suppose they have initiated proceedings under what is that now, 84 BNSS.
No,
then we don't know.
That is not...
We don't know. You may not disclose it.
At least,
But given this passage of time, we'll have to think about those aspects also. No question of granting you anticipatory bail
at
in
least,
relation to a FIR lodged 1 year ago.
will not kindly see the facts, can't you see?
Not on facts. We are telling you that it's not possible to grant you anticipatory bail in relation to an FIR filed 1 year ago, in which a charge sheet was filed in December 24. Sorry. Delay could not, however, we find no good ground in reason to interfere with the impugn judgment, given the length of time that has passed since the registration of the FIR and the filing of the charge sheet. Especially petition is accordingly.
Well, 8 is an application for bail.
It's coding hospital notice. Below issue notice. Issue notice returnable on 18 December. So which will be effective for all modes including this. Delay is there, delay comes 7 days. Item 9. Grant of against the grant of bail.
Is connected to
Someone is there?
Item number 10 along with 58.
Lordship, I am praying for past events.
Item number 11.
Please, Manoj. Manoj, this is a regular bail, Manoj. He's been in custody for more than 2 years and 3 months, Manoj. So
Three
there are
similar cases.
Manoj, I'm on bail on 3 similar cases. Manoj, rest of the cases are for
You
one.
seem to be making good use of the bail order though, by committing one more.
Those were earlier, Manoj. Not that after registration of this very year. Those were earlier, Manoj. Those
So
cases,
now you've turned over a new leaf.
Manoj, there is no other case apart from this which has been registered now. Manoj, kindly see, Manoj, it's the entire paper. The allegation is that they have made the payment in cash. Now, initially,
Punjab and Haryana, this is a regular feature though. Everyone wants to send his son or daughter abroad for a job and they get duped like this.
Manoj, but the primary allegation was against accused number 3, who is Mohit. What the complainant, they said that they met him first and thereafter he made us meet the petitioner even. Now subsequently, if Lordship would go to the FIR, he
So returnable on 5th January.
was in the meantime, may I serve the standing counsel, Lord.
Service may be services effect. Sorry. Permission is granted to effect service of notice upon the learned standing of the designated counsel for the state of Punjab and Haryana. Which one is it? Haryana or Punjab?
Haryana. DP of Residence.
Number 12.
This is MD.
Please, Lordships. Lords, this is arising out of NDPS Act. Admittedly, Lords, even as per the case of prosecution, the substance which has been seized weighs 11.51
Less than
gram,
commercial.
less than commercial. So it's an
More than the small quantity.
yes, it's an intermediate quantity. But he has been behind bars since Lords last 14 months. 27th August 2024 is the date of raid or the seizure. And in wee hours of 28th of August, FIR has been registered. Investigation is complete, charge sheet has been filed, my lords. And there are no criminal antecedents of the present petitioner. There are 2 other co-accused. I may not claim parity, my lords, but they have been granted bail because they are apprehended only on statement of the present petitioner. And subsequently, my lords, released on bail on regular, enlarged on bail. Those charges are not framed as of now.
There are around 19 witnesses cited. But as of now, there is no list under section 294 submitted to the special court. Twice earlier, the application was filed. Once it was withdrawn. After charge sheet, it has been rejected. The first order malot should get the reasoned order malots. The interim order is of 11th of July. There is one reasoned order which was passed.
Which page is that?
That reasoned order is at page 162, malots. So this was the initial order passed. This is after filing of charge sheet, of course. 10th February, it was pronounced. Lordships has that at page 162. Though it was tried to argue that this is a case of parity, that was rightly not distinguished, I would say. At page 164, last but second line, the distinction is that the present petitioner was apprehended while he was in actual possession, when it was not the same case so far as other accused persons are concerned. So after this, after some time, I again applied for bail. That was turned around by the special court as well as by the Honorable High Court. Perhaps.
Though,
Well,
I have not the latest judgment with regard to compliance with section 50 CRPC. Grounds of arrest. That you raised before the sessions judge, page 173.
Yes, that has been turned on at page 170.
On the ground that you were informed. It is not in keeping with what the said in that.
That was turned on saying that there is already a compliance.
Issue notice returnable on 5th. Service shall be effective.
January, your officer said.
Yes.
May I have the liberty to serve the standing counsel notes?
Service should be effective.
The order also indicate if they want, they can file a counter because this date will be almost after 4 weeks.
State is at liberty to file its counter. Don't say liberty. The notice would be sufficient indication that the state would be required to file a counter affidavit by the next date of hearing.
Item number 30.
Lordships. Lordships, here is a case where a history sheeter, if you see the criminal antecedents, first thing Lordship will see one thing, how he has played around the High Court. Kindly have he has first filed a quashing petition, and then when he withdrew the quashing petition, and then filed a bail petition. Would Lordship kindly come to the quashing petition, just come to the cause title of the quashing petition.
What about the other accused who's been granted bail on parity is now?
Parity, I have a strong, I'll tell you, Lordships. But before that, one thing I'd like to just, please for a moment, Lordships. Kindly come to the cause title at page 70. This is the quashing petition filed before the Allahabad High Court.
Yes.
Kindly mark it Ajay Pal Gupta, aged 37 years, son of Ram Pal Gupta, and see the address of Uttar Pradesh. Now kindly have a look at the cause title of the bail petition. Page 105.
Yes.
Ajay Pal Gupta is a Sonu Chaudhary, son of Shri Khobarhub. Please do compare these, both of them, and see the address here. Khajuri Khas, New Delhi. He has played around every authority, every person, even before the Delhi High Court, before the Allahabad High Court, he does this.
This case was filed at, I see, in Allahabad, but showing the Delhi.
Father's name is different.
Father's name also is
yes, Lordships. Please see the father's name.
What was the other one? I didn't notice the father's name. Rampal Gupta.
And here it is.
Rampal Gupta, Sonu Chaudhary.
And this is Shobharam.
I see. Alias Sonu Chaudhary, son of Shobharam.
Now, he has disclosed 4 cases, but he has not disclosed the fact that he has jumped bail.
This is the one in which you find those Aadhaar cards in it.
Yes. He has got
Where is that?
many Aadhaar cards, many PAN cards. For the most startling thing, lordships,
Oh, I see.
most startling thing,
Yes.
though he has disclosed 4 cases, but he has not disclosed the fact that he has jumped bail. Would lordships have these judicial orders? Please.
He's jumped bail also.
Yes, he has jumped bail. Lordship will kindly see. This is FIR 229 of 2017. This is the case pending in Delhi High Court. And we have annexed that. Lordship will see his own, he says about 4 cases. I'll just connect it. Please kindly come to the criminal antecedents at page.
So now the name has changed to Sonu Seth.
Sonu Seth.
Sonu Chaudhary, Sonu Seth.
Now please see what is last 2 paragraphs.
How many names does he have?
We don't know. And if he is released today after 2 years, he has absconded for 2 years. Now see what the court orders. It's the first order I'm placing, 25-125. Reports produced. Thereafter, it is stated by the learned APP for the state that the accused Munna and Sonu are intentionally and deliberately avoiding process of the court to prolong the process with request to issue NPWs against them.
The same Sonu according to you.
Yes. No, he has talked about this case in his petition.
I see.
He has talked about this. So with such a person, such conduct,
To notice.
he is still not been released, lordships. He is still there. So lordship will stay the order.
12th November.
Yes. On instructions, I'm saying he has still not been released.
Issue notice returnable on 2nd February. Service shall be affected by all marks including industry. We are informed that respondent number 1 deliberately showed his father's name differently in different proceedings, perhaps to gain some undue advantage. That apart, he is stated to have, he jumped bail or he was absconding? He was absconding.
82 proceedings have been now initiated. The next order indicates that.
He was absconding in relation to FIR number 229 of 2017.
Pending in Delhi.
Which police station was that? Geeta Colony.
Geeta Colony police station.
Geeta Colony. You registered with Geeta Colony police station in Delhi. As is evidenced by the order dated 26/4/2025 passed by the learned Judicial Magistrate First Class within that -2 within brackets East Karkargoma Courts, Delhi. We are further informed that respondent number 1 has not yet been released from prison pursuant to the grant of bail by way of the impugned order. If that be so, the said order shall not be given effective till the next hearing.
I'm so very good. Very good.
Answer item 40. Madam, I'm seeing short accommodation matters kindly Monday, next Monday.
Right?
Manage in this matter, London City Council is appearing.
Mr. Luthra,
But we have to.
you're changing.
Not Mr. Luthra has to appear, but we could not get the appointment. That's why we could not engage.
The request was done something for the petitioner. The matter is at the list on next Monday. You want?
Yes, madam. Next Monday.
Next Monday.
Much obliged, madam.
Let us then.
Yes, madam.
And counsel for the appeal.
Yes, madam. Appeal against the order
For the
of the tribunal.
seeks an adjournment on the ground of ill health. But this argument of what? Limitation not commencing, you will have to perhaps convince us on that. Otherwise, the delay is uncondonable.
My lord will satisfy. My lords had actually condoned relisted a matter, a connected matter last week. This is on the 17th of.
That was within time or that was also beyond time?
That was beyond time.
That was also beyond time.
Those appeals are connected. Would my lords kindly list this on the 12th of January together?
12th of January. Don't tag it. Let's say 12th of January.
Item number 16.
Supreme.
The High Court has denied him.
Colossal lethargy.
Milords, 25 years, Milords.
Well, colossal lethargy, what do you expect?
Milords,
Giving you the benefit of that enhancement itself, you should be thankful for.
Milords, what has happened, Milords? The evidence has itself started in the year 2014.
You don't pursue your reference.
Milords,
You just let it go, dismiss for default in 2018.
Milords, kindly agree.
Then you file a writ petition in 2024.
Milords, the original landowner, Milords. Milords, the present petition.
But how are you entitled to seek interest when you sleep over the matter and let things lie for decades together?
Milords, but may kindly appreciate, from 2000, the reference was filed, Milords. It was registered in the year 2006. Milords, for these 6 years of delay, Milords, petitioner is not responsible. That is administrative.
That doesn't mean that your delay is to be just wiped out.
Milords, but
It is the exchequer who has to pay you this interest for a period that you slept.
Milords, but Milords, that has not been done by the High Court. Straight away, Milords, from the date of filing of reference.
No.
Milords, may kindly.
Colossal lethargy is what you have been
High Court
found.
done, Milords. I am not denying that some days may be deducted, Milords. Milords, what has High Court done, Milords? From the date of filing of reference itself.
That is
delay, Milords.
Sorry.
Milords,
Delay condoned, however, we find no good ground and reason to interfere with the impugned judgment.
Milords, there is a harsh order, Milords, because this petitioner is, Milords, the grandson of the original.
You will get the benefit of the enhancement, be satisfied with it.
Milords, may kindly, Milords, may at least direct, Milords, that the delay period be calculated by the reference court, Milords.
No.
Because it is the
The High Court has already decided it. Where is the burden
High Court has not considered
giving that issue open? Sorry, Counsel.
Oblige.
Number 17.
This matter.
Yes.
Whereas I am ready to pay the amount. However, I need some time.
You already had enough time. You asked for 30 months installment.
Financial difficulty, Malad, I am facing right now.
The High Court permitted you 25 monthly installments instead of 30.
I am ready.
And you committed default in the first 2 months itself. You paid that 12 lakhs and nothing else.
Whereas financial difficulties, I am.
That doesn't mean that you keep on buying time. How long will the bank also wait?
I am in the hands of my lordship.
No, sir.
Please, Malad.
Your sympathy we cannot, and that too with a 376 days delay in filing. Sorry, Counsel. We find no good grounds made out to condone the inordinate delay of 376 days in the filing of the special petition. That apart, we find no grounds to interfere even on merits. The condoned delay petition and the special petition are accordingly dismissed.
Item number 18.
Mayor, please.
Here, Mr. Balbir, though the registry has not raised it, in fact, I just spoke to the Registrar Judicial about it. Please look at your dates. You have filed this appeal on the basis of a free of cost copy, certified copy. If it is a free of cost certified copy,
Yes.
you are not entitled to deduct the time taken by the registry of the NCLAT to furnish you that free copy. It is only when you apply for a certified copy that you can deduct that period. Here you have conveniently deducted that period. You will be within time, but there needs to be a condoned delay petition.
Well, I'm sorry, I have
You
not
will,
examined.
you will still be within time. You are not barred by time because you are within that condonable 15-day period.
No, I will.
But you need to file a condoned delay.
I will do that. That might be.
But that's only to let you know about the technical aspect.
Please.
On merits, how are we
Well, I'm
interfere with this matter, Mr.
Yes,
Balbir?
briefly I can give a background, if subject to my lord's ruling. Well, the personal insolvencies and the corporate insolvencies are covered in 2 different chapters. Section 94 deals with, and the process is different from Section 7 process, which is there. In this case, against the corporate debtor, because the principal debtor is a corporate debtor, goes on, and that is completed on 12/1/2021. After that, my filing is 3/4/2023. So the trigger of the proceedings against the principal debtor ends on 1st of January 2021. I am within time. What they say is because SRFASI proceeding against the corporate debtor
Not just the SRFASI.
Yes.
They invoked the guarantees against you in 2016 and 17.
No, that is through the filing section 13 before this thing, because
once those personal guarantees are invoked,
yes,
you're obviously put on notice.
That's what that was saying. The difference is to,
and you don't come up till 23.
Yes.
If
So there is
if we count it from 2017, also it expired in 20.
No, wait. First is the section 94. Section 94 came in the statute book in 2019.
Very well.
That's the position which has been there. Prior to that,
At least from 2019, then 2022.
I could have gone for, but I have something more to say. When I filed my application, I had the lenders who were the corporate financial creditors and the operational creditors. What the tribunal has done is, instead of looking at the operational creditors, solely looked at the financial creditor, which I agree. I can debate on this, which date is there. Kindly see my application, which is page 348 for a minute.
348.
348, which is on
volume 2.
Volume 2. This is my section 94 petition.
Very. Yes.
And as a statutory form starts from page 360. And it is in multiple parts. Part 1, I'll come specifically to first just to show that my petition is at 348.
Yes.
The form starts at 360.
Yes.
And part 3 is the detail of the debtors, creditors, which is there, which starts from page 366.
Yes.
On the first page, on the top of the page, State Bank of India is the financial creditor. Now, kindly, if my lords can kindly go to 368, the second financial creditor, Indian Bank, because this is a consortium lending. And I take it for a minute that what my lords are saying is right. 368 is the second consortium lender. Third is the page 370 is the third, because there were 3 consortium. Fourth, the operational creditor, 372. Now, kindly see this, that in this case, the debt due is serial number 6 and 7. On the page, the serial number 6 on this. Vigyan Arora, the total debt is 413. 6 says that the debt due was 24/10/2022. Date of default is 24/10/2022. I need not succeed in case of to meet the limitation, all the creditors. Even if the one creditor is outstanding, section 94 kicks in. Now, what is the fate of the remaining can be taken care because there's a complete resolution process which is there. You can't ignore to say that even if one is within limitation, the section 94 is to be admitted. Section 94 is the only kickstart. Now, you can't say that I will look at only the financial creditors and I will not look at the operational creditors. And this is part of my original application. RP agrees with me on this. RP submits a report under section 100 which says that no, this is to be entertained and there is a jurisdiction competence of this court. I can show RP's report for a minute.
He recommended, yes.
He recommended, and more than recommendation, 506. Because tribunal is functus of it.
File your condolence petition.
I'm grateful, I'll file this.
And counsel for the petitioner seeks an adjournment to enable him to file a condolence petition in relation to the filing of this under section 62 of ABC.
May I request if my lords can issue notice subject to my filing and undertaking. Every day I may not be able to explain this every day.
We condone the
very well.
Matter is
I take that. I take that. Yes. Well, I'll file in a week's time, honestly.
1 week.
And my lords can give a date.
Next Monday?
Next Monday, my lords can keep it. I'll do the needful before that.
Correct.
I'm grateful.
Item number 19.
Well, may I just mention to your lord.
Against this 30th November 2008.
No, that's because I was not party.
Badge of.
No, I was not a party to this.
Your members would have been.
No.
There were quite a lot of SLST.
So that's why we filed a review.
Mr. Sibal,
that's why we filed.
Just trying to breathe life into a dead body.
No, it's not dead at all. It's not dead at all. But then we can demonstrate to your lordship. We file an affidavit. But we have not. I'm sorry to say, brother.
It can't be reopened and revisited.
No, but I have said it
again and again. Look at the order.
Can't you see the question?
The assembly against that judgment was dismissed in 2022 after condoning the delay. So even then,
I'm not a party to that.
You can't say that I'm an association. Therefore,
you
are a Kotwar association.
No, I was not being a party, brother.
You are not a party. Your members must have been
party. No, they are not. I will demonstrate.
We don't even have the details of.
All right, I will file. I will file an affidavit. Please allow me.
Numbers.
Allow me. I'll file an affidavit to show that I was not a party in any sense of the word, neither the association nor I. That's why I filed a review when I got to know. It's only last year, mothers, that they came to me and said that you have no right. Allow me, sir. Allow me to just
is completely wrong. Judge says I'm not party.
At some point of time, we need to let sleeping dogs lie.
The question is, I got hereditary rights.
Where is the question? All that has been considered, self-dismissed long ago. And now you suddenly come up with a review petition after...
1 minute for your lordship. 1 minute of your lordship's time. Just hand over this, please. Just here. Now, what was the question of law referred to the division bench? Just see that.
Your review petition was in 2025 in relation to a 2018 order.
That's correct, because I got to know in 2024.
There is a question of your claiming ignorance of what...
But he has admitted that the order says that I was not a party.
You are not a party. Your ignorance claim is to be taken with a balance.
That's the finding against me. But if only on delay,
that is what we are finding.
All right.
All right. In the face of it, you are trying.
All right, just see that question of law for a minute.
Yes.
Page 4,
yes,
which is referred to. Just see that. Whether a court bar holding service land under section so and so can be granted Bhumi Swami rights over such service land in view of the provision contained. We say, yes, you're right. But what have they considered? This is not service land. So they have given findings beyond this, Maharaj, which have affected me. I am not holding service land. My right this is
both wars, all of you were in the same boat.
No, Maharaj. No, there is a judgment in my favor.
You're not inclined to interfere.
All right.
We find no ground.
Just dismiss it or delay then, Maharaj.
To condone the inordinate delay in the filing of the special leave petition.
Have another chance.
Under inordinate delay of 2,409 days in the filing of the special leave petition against the primary order dated 30/11/2018, which was in fact tested before this court in a batch of special leave petitions, which were dismissed by or dated 25/2/2022. The special leave petitions accordingly dismissed. So we can dismiss this and then late handing over of side. What is it that you want?
What was supposed to be completed?
You don't hand over the site is the finding.
That's the finding.
There is a question of sitting on that finding of fact. 34 court, 37.
Even the hindrance register does not say.
Mr. Raghupati, award is valid. There is no question. We find no good ground and reason to interfere.